In this video, we're going to talk about how to handle the situation where you receive a patent assertion communication from a patentee. So this could be an email or a letter or some other communication you receive from someone who claims to own rights in the patent and claims that a product or service you offer or perhaps are thinking about offering infringes that patent. The first thing to understand is that patent assertions are highly fact-dependent, and there's no proven recipe that would address all situations. Let's talk about some of the things to consider, though, if you are threatened with patent infringement from someone who claims to own patent rights. First is you need to make sure you're not destroying any information that could be evidence in a later lawsuit. Now, this means more than just making sure you don't throw away or shred information. In today's world of electronic information, it's likely that servers are routinely overriding some of the backups of your emails or other information. You may need to take affirmative steps to make sure that this routine destruction of electronic information stops. Because the law now is that once you reasonably anticipate litigation, you have to take affirmative duties to make sure you're preserving information that may be relevant in an eventual lawsuit. And it may be the case that that duty starts once you've received a threat of patent infringement from another party. Now, once you receive that letter, you have several choices of what you can do. But it probably makes sense to consult someone that's familiar with patent litigation to understand what your options are and how to proceed. Because anything you do is probably going to be key evidence in an eventual dispute. You do have the option to ignore the letter and not respond at all, but you really want to think through and understand the motivations of the party that sent you the patent assertion to understand whether this is a prudent course of action. In some cases, it may be possible and reasonable to actually comply with the request. Perhaps the activity that's being accused of infringing someone else's patent rights isn't essential to your business. And once you examine the other party's patent, their claims, their motivation, and the importance of the accused product or service to your business, it may make sense just to change your activities so that you're not angering this other party. In most cases, it's going to be important to do some due diligence to understand what's motivating the patentee from making this claim against you. You may contact the patentee directly to hopefully explain what you're doing, understand their motivations, understand why they think you're infringing a valid claim from their patent, and perhaps even understand whether there's any room to negotiate a resolution to the dispute. There are ways to challenge someone's patent. For example, once someone has alleged that you infringe a patent that they own, you have the ability to start the lawsuit yourself. You don't have to wait for them to sue you. Now, patent litigation, as we'll discuss in a future video, is very expensive, so you really want to think carefully before you start this process. But it may be beneficial to you to start the lawsuit by filing what's called a declaratory judgment action. That means your lawsuit seeking a court to declare that either you don't infringe the claims of the patentee's patent or the patentee's patent claims are invalid or unenforceable. The main benefit to this is you can usually choose your forum. You can pick which court you start the lawsuit in. And there may be some perceived advantages, either geographical or based upon how different courts handle their patent cases. Some move faster, some move slower. Some judges or jury bases may be perceived to be more friendly to a patentee or an alleged infringer. There are also new ways to challenge an issued patent before the Patent and Trademark Office. These may be less expensive than starting a lawsuit through declaratory judgment action. And generally, these actions involve starting a process before the Patent and Trademark Office to get the Patent and Trademark Office to examine whether they made the right decision when they issued these claims in the first place. And we'll have a separate video that'll talk about these specific administrative procedures before the Patent and Trademark Office. Another possibility is to strike a licensing agreement with the patentee. Now, this may either be just a financial arrangement where you offer to pay this person either in an upfront payment, running royalties on sales of products or services that allegedly infringe this patent claim, or perhaps giving the patentee some equity in your business. Another possibility is to grant a cross-license. And this is one of the main benefits from having patents yourself or having pending patent applications that another party may see value in. And a cross-license would be each of you granting permission to the other to exercise rights that you wouldn't otherwise be able to exercise. Now, whether or not this cross-license has any value to the other party really depends upon their position. The other party could be a potential competitor that's practicing technology in the same space, and they could see huge value in having rights under your patents. But the other party could be what we call a non-practicing entity, an entity that's not trying to actually sell or develop any products or services, but merely going out and enforcing their alleged patent rights against other parties, seeking to obtain some financial reward, in which case they probably don't care about having a cross-license to your patents. So again, it's really worth finding out what's motivating the other party and what's the basis for their patent assertion against you. And that's a very general overview of your options in responding to a patent assertion from another party.